On this morning's docket. That is case number 106273, State of Kansas v. Sharon Huddleston.
May it please the Court, Meryl Carver-Allman, Capital Appellate Defender on behalf of Ms. Huddleston. And Justice Nuss, if I could please have 4 minutes for rebuttal.
4 minutes is granted.
Thank you. I'm going to lead in just with the first issue here, and that's this misconduct issue. Basically, our argument is that the prosecutor improperly defined premeditation, and that matters because premeditation was the only real issue in this case. I don't think there can be any argument about the law of premeditation. It has to happen before the homicidal act, I believe is the exact language, maybe from Gumby.
Or concurrently.
Or, yes, and that's fair enough too, under our law currently. However, it can't happen 10 years later. It can't happen, I would argue, 5 minutes later. So in this case, everything that happened after Ms. Huddleston poked Mr. Stover with the needle is not premeditation. Yet, in closing argument, the prosecutor gets up and several times says, this is after she stabbed him with the needle, says when she told him to go lay down, that's premeditation. When they take him to the garage, that's premeditation. I'm paraphrasing this, obviously, but the full statement is laid out in my brief. They never call 911. They never call the police. They never call EMS. That's premeditation. They load him in the trunk. And it's very important here. I mean, Justice Johnson?
It seems to me that we have the distinction between acts committed afterwards that are indicative of a premeditated intent versus actually being the premeditation.
Absolutely.
If the prosecutor had made these arguments, they went for a nap and left him there and did all this, shows indicates that this was a premeditated killing. That would have been okay.
That would have been okay. Yes, absolutely.
Yeah, and it's pointing to actions that just corroborate the state's theory. Isn't that what happened here? I mean, I understand that they called it, you can look at evidence after the fact and call it premeditation, but isn't what the state's doing here just corroborating their theory on premeditation by showing the actions even post-death, but post-infliction of the wound or the infliction of the injection?
I think it's very important here. The state did not say you can infer premeditation. The state did not say these show that there was premeditation before the stabbing or poking with the needle. They said this is premeditation. It's a very small difference in word choice, but here it's vitally important. And actually, just as I was looking at this in preparation for argument, started looking back at the basic instructions even, and in this case, instruction 1, which is I think given in every criminal case, is this argument that this instruction that says statements and arguments and remarks of counsel are intended to help you understand the evidence and in applying the law, but they're not evidence. If statements are made that are not supported by evidence, they should be disregarded. So that tells the jury what to do with sort of factual misstatements, but it doesn't really ever tell the jury what to do. And in fact, it says statements of counsel should be used to help you apply the law. So that leaves, I think that sort of piles on the confusion here too, because you have instructions telling the jury, look to counsel for how to apply the law, at least in part. And then you have counsel misstating the law. And that sort of goes, I'm getting into harmlessness here too, but I mean, again, I think that the law of premeditation is absolutely clear here, and my argument is it's a subtle difference, but it was a distinction the prosecutor did not make, and therefore this was a misstatement of law. Moving on specifically to the prejudice part, the test for prosecutorial misconduct, it's Part 1 is the statement outside the latitude granted to a prosecutor. Part 2, did the statement prejudice the defendant and deny her a fair trial? And in several of this court's cases, there's a line, and it's specifically in Henry, that says a misstatement of law denies the defendant a fair trial where the jury could have been confused or misled by the misstatement. And it hasn't always been, in fact, I can't think of a case where it's been applied specifically this way because of various factual problems and issues. Specifically in Henry, I think there was so much misconduct that this court ended up deciding on other stuff. But to me, if the court is following that law that's been stated in the cases, I don't know that we need to go into ill will and all of that. I think the question is just, did the statement confuse the jury? And here, obviously, our argument is that it did. The only issues in this trial were premeditation and intent. The prosecutor, Justice Wells, did you have a question? I'm sorry.
No.
Oh, I thought I saw you raise your hand. I'm sorry. The only question here was premeditation and intent. That is exactly what the misstatement went to. Therefore, I mean, you can't say that the jury couldn't have possibly been confused by the misstatement. Now, if we go into the more traditional prosecutorial misconduct analysis, the ill will, gross and flagrant, and then the Chapman test at the end, I think this is reversible under that test too.
Let me just clarify. Are you suggesting that being confused or misled by a misstatement is something different than the Chapman test? That there's a likelihood?
I think they're similar. I mean, and I think those two parts are actually very similar. And maybe that's what the case law is saying. This is something that I've never particularly understood because it's in there and it sort of seems like, okay, well, if I have a misstatement of law, then I'm, it's not necessarily an automatic ticket to reversal, but it makes it stronger than if there's just a factual misstatement or something like that. But it is, as you say, it's closely related to the Chapman test.
And we have said that any of those factors alone, the ill will, the gross and flagrancy, or the likely to have made a difference in the outcome could cause reversal.
Absolutely. Absolutely.
I'm not sure we're saying anything different in those cases.
And maybe not. As I said, it's just a line that's been in several cases, and I'm not sure I understand how it applies specifically, and maybe that's how it is. Maybe that's exactly correct. In any event, under the traditional analysis, I see cases, I've had a couple of misconduct cases now, where, and it's not as if prosecutors are getting up and making obviously really inflammatory, I think the latest bad incarnation of it was the victim being compared to a barbecue or something like that. A statement that's just so off the wall. We don't have that in this case, obviously. But this has been law since the 1800s. It's in the pattern jury instructions. The premeditation has to happen beforehand. It's in the pattern jury instructions. Prosecutors should know this law. I think at a certain point, this court has to take that misstatement as evidence of ill will and as gross and flagrant conduct. I mean, this is pretty basic law that everybody should know. And then on to the Chapman test. Again, I just don't think the state can meet that in this case. Premeditation and intent were the only issues. My client had admitted to the killing. It was all about what her intent was beforehand. And there's certainly, I would not stand here and argue that there is not sufficient evidence of first-degree murder in this case. There is. But there's not overwhelming evidence. There was conflicting evidence, too. There's the evidence that my client said that they tried to counteract the insulin with sugar water. They tried to save him. She said she didn't mean to kill him. She just meant to knock him out or mess him up. She said that her friend Sharon had told the other Sharon, that it wouldn't be fatal. And she said, probably the most damning statement that she made, I could just kill that SOB. Honestly, I think this morning I probably told my husband, I think I'm going to kill somebody if I don't get some coffee. I don't think he felt in danger of losing his life over that statement. And there's evidence in the record that my client said, that's just how people talk sometimes. I didn't really mean to kill him. So, while there's certainly sufficient evidence of premeditation, it's not overwhelming. And because the misstatement of law went so to the heart of the key issue in this case, our argument is that it's reversible misconduct here. If there are any questions about issue 1, I'd be happy to take them. Otherwise, I'm going to move on just briefly to issue 2.
Proceed.
The main thing I wanted to talk about with issue 2 today, I don't think I can improve upon the brief much, but I wanted to address the state's argument that the not having the letters redacted was somehow invited error. And specifically, the state cites State versus Deal. In that case, some videotapes were admitted that had prior crimes evidence. It was like a confession tape. I get the idea from the case. And the defendant mentioned prior crimes, and the defense attorney elected not to have that redacted. I think that's different from this case. In this case, I think the defense attorney honestly was just trying to deal with a bad ruling. He didn't want those letters in at all. But if they were coming in, and I can see his point if you read them, first of all, what do you redact? Because it's really, as the state says, it's the general sense of the letters that tells you she's in jail. You know, she doesn't start the letter, writing you from cell house A, where you could just easily redact it. So any redaction in this case probably would have taken out kind of the more humanizing parts of the letter. I really like the Twix bars, the things that might make your client more sympathetic to the jury, and leave just the bare bones, let's make it look like Sharon did it, statements, which I could see why a defense attorney would not want to do that. So my argument here is it's not invited error to try to ameliorate a bad ruling. And so to that extent, Justice Johnson.
I understood your argument to be that they were more prejudicial than probative because they didn't prove anything except she was incarcerated. And my question to that is that if an accused person didn't commit the crime, why do they try to frame someone else? To me, it makes it more probable than not that someone, or at least it's a consciousness of guilt when you're trying to blame someone else and recruit an accomplice to frame someone.
I think it absolutely, and I think I say this in my brief, it is definitely evidence of who the killer is. But our argument is that as to that point, it's cumulative evidence because she had admitted to stabbing him with the insulin, and she had never tried to. I mean, she didn't get up at trial and try to take back that statement. So you're absolutely right. It is probative of who the killer is, just cumulative to other evidence.
So our standard would be abuse of discretion.
It would be.
Any further presentation?
Not unless there are any more questions from the court.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Boyd Isherwood on behalf of the state of Kansas, and I guess I just hope that we haven't reached the point where small differences and subtle differences set at the spur of the moment is how we're going to determine whether we're going to apply prosecutorial misconduct and reverse.
Subtle about repeated statements, that's premeditation.
I think that and if you don't see the distinction, then you don't see anything wrong with saying it. I think it was
how's a jury to make a distinction like that?
Follow the instructions, to which there's been no indication that the instructions were incorrect at all.
To me, at best, this argument of the prosecutor is an attempt to mislead the jury. There's nothing that really in that context is those repeated, 6 times where that's said. Is there any attempt to say you look at these circumstances and from that infer premeditation? It just says that's premeditation, period.
I think that's the gist of the entire argument. When you look at it in its context, that's what they're saying. You can look at these circumstances and it helps show premeditation. They say at the beginning, they refer back to the instruction. They refer back to the instruction in rebuttal closing. I think that's what they believe they're doing. And for instance, on page 8 of our brief, referencing, I don't know what page exactly, but somewhere in between 109 and 10 of record volume 11, afterwards, what do? They wrap him up in a blanket and they load him in the trunk of the car. They head out to Grand Lake. Why? Because they have a plan. I think that's exactly what you're talking about, but not in as many words. That's exactly what the prosecutor was doing. I believe it was Justice Rosen. I'm telling you about the things that show that what they did before is premeditated. They had a plan. They're sticking to the plan.
I don't disagree with you if that had been the consistent way it had been done, but it's not. In fact, the worst, I think, is to say that's premeditation after the fact.
Well, I think that
you interpret that statement any other way than to mislead them about what premeditation is.
As I indicate in the brief and as I will argue today, I think At best, what we're talking about is the prosecutor's application of the facts of the case to the law. There's never been a misstatement of the law by the prosecution, either one of them, in either the opening or the closing. They tell you to look at the judge's instruction, which, again, there's no argument that it's incorrect. It is correct. They then tell you that you can look to circumstances before, during, and after to help show premeditation, and then they launch into those things. So at best, I think what's troubling opposing counsel, and maybe what's troubling the court, is that maybe we don't think that those individual factors they're talking about, maybe you don't share the prosecution's position that it does help show premeditation, but they're certainly not defining premeditation. The allegation is a misstatement of the law. If the prosecution thinks that factor X might help show premeditation and you disagree, well, I don't think that helps show premeditation.
I still don't understand how saying premeditation after the event is not a misstatement of law.
Well, I think that they're talking about two different. They're talking about premeditation, but they're saying you can look at things after the event, just like the established case law indicates. You can look at actions after the death blow, or however you want to state it, to show that the blow was premeditated. And I think that's all they're doing. Is it inartful? Possibly. But is it reversible misconduct? No.
It's more than inartful. It's telling the jury, you don't even need to make a finding of fact. If these facts are present, this is premeditation. It takes it right away from them. And
Well-
that's exactly what their role is, to look at the facts and apply the law. And this is blending those two responsibilities.
Well, I don't think so when you look at the argument as a whole. And again, they start out by telling you what
I
exactly.
understand your argument, but as Justice Luker points out, the twice saying premeditation after the event, that's a misstatement of the law. You can't premeditate after the event. You can look at factors after the event to decide whether there's premeditation.
And I think that's
And-
what they're
and-
communicating. When you look at the
Well-
the argument as a whole,
Let's just say, for the sake of argument, let's disagree and say that that is a misstatement of the law. And it's a misstatement of the jury's obligation here as far as finding premeditation and how they do that. How would you address the prejudice issue?
well, first of all, and under your scenario, I don't think that's an accurate portrayal of the case. But under your scenario, I do think that the case law indicates that if the prosecutor correctly says it and incorrectly says it, then you have been loath to find ill will and gross and flagrant. So I don't know under your scenario if we can start there, but I think we should. So, but after that, if you're talking about simply whether there was overwhelming evidence, that type of thing, clearly here there was overwhelming evidence of premeditation. We've got not one but two. First of all, we got a plan. Then we put the plan in action, and the plan is to kill, and not one but two shots, and of insulin. And then when there's a report, I guess I can say this. When there's a report from the victim that something is happening, we don't even, there's no aid rendered. We just, okay, go die, thank you. I mean, so I think the facts of this case are strong enough to come over any subtle differences or however counsel phrased the misconduct allegation from the podium. Again, I think we need to look at the established case law, not only with respect to premeditation, but also with misconduct claims. We've got to look at it in the case as a whole, the totality of the argument, and you cannot, the one thing that is sure is you cannot read this argument in its totality and say that the prosecutor never said correctly what premeditation was. I just think that the worst case scenario here is the application of the facts to the law. That's where I think the court is of the impression that the prosecutor may have misspoken. And I do not see inarticulate expressions of the law, misspoken expressions of the law as being this court's measuring stick for reversal of otherwise valid convictions. Unless the court has any questions on the first issue, I'll move on to the second issue, which was the introduction of the letters. I'm sorry. I don't see how this isn't relevant when you have someone after the fact trying to get another party to concoct a story in almost as many words. It is a consciousness of guilt. It also appears as though one of the issues that this would be ripe for would be credibility. And as much as opposing counsel would like to step up to the podium today and indicate that, the only issue here was this, or she totally agreed that she did this whole thing. Well, she's making an attempt to distance herself from even being the one that gave the shot. And then she's asking for jury instructions, second degree, these kinds of things. So it's important, as in any case, for the jury to be able to view credibility. And when someone is trying to get to manufacture a story after the fact, there is no way that is not absolutely important with respect to the issue of credibility. In fact, opposing counsel indicates in her brief that credibility was of paramount importance in this case. Exactly. Unless the court has any questions on these issues, I respectfully request that the convictions be affirmed.
Any further questions of counsel? Thank you, counsel.
Thank you.
You reserve 4 minutes for rebuttal.
Thank you. May it please the court, I just want to briefly get up and talk about this idea that if the prosecutor says it correctly in there somewhere, then that smooths over all errors. First of all, I think the obvious argument to that is which part of that is the jury supposed to believe. But beyond that, in this case, the defense attorney actually got up and tried in his closing argument to fix the misstatement of law. He got up and said, now wait a minute. The prosecutor said that these things are premeditation, and he starts to talk, and the prosecutor objects. And the judge makes the defense attorney reframe his argument. So here, even the defense attorney is trying to correct this, and the court endorses may even be too strong of word, but I think you get the idea I'm trying to convey. The court almost endorses the prosecutor's misstatements of law at that point. So I think, and I recognize that there's case law to the contrary, I think this idea that as long as, if he can say it correctly one time, if he says it incorrectly, I think Justice Lugar said 6 times, then somehow that just takes care of it and magically wipes it away. I just don't think that can be the case.
Well, they did clarify in closing rebuttal. The second prosecutor who comes up after the defense has attempted to make an objection, there is a pretty clear statement, and that is that he or she says not that these acts that they happened after premeditated acts, but that the acts and the evidence that you heard about, what she did before, during, and after, these things that show she meant to kill him, she planned to kill him beforehand. I think that seems to be trying to address that objection that the defendant made.
She gets the word show in there. Yeah. I think that's true. But she also says, and I think it's a couple pages later, that Ms. Huddleston's premeditation was going on all those 9 hours after Mr. Stover had been injected, after the fact. So again, yeah, she tries, but which is the jury supposed to believe, A, and B, even, that statement that you just read, and this isn't your fault, obviously, but it's almost incoherent.
It could be the way I was reading it.
Yeah, no. I remember reading that. What is she saying exactly? Yeah. So,
but we've got some law that sort of supports that prior to death, you can premeditate the manual strangulation. You've got all that time until they die to form.
Because it was the 9 hours without, or the 5 hours, whatever it was, without assistance that also contributed to his death. It may have been saved if he'd gotten to a hospital right after the shots were given.
And I think that's an interesting question. I think Gumby obviously is a strangulation case I think you're referring to. But also, I think the language in Gumby says the homicidal act. And it's sort of, there's a factual difference here between the stabbing, which is the direct, was sort of the direct cause of death here, and strangulation, which...
Well, but let's talk about another case then. Let's talk about you knife somebody. You leave them to bleed to death.
And they died 9 hours later. I would still argue that the act there is the stabbing. And so.
Any further presentation?
No, sir.
Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.